A very good evening, Team Zimbabwe. Masquerasi. So I'm very sorry my network is misbehaving, but I hope that I will be able to bring this to you because it's very important for us to communicate important matters. Triple C, Citizens Coalition for Change, announced the reason why they did not go to court because everybody was expecting to see Triple C going to court, but last minute they ditched or they shelved that plan to go through the courts, and they choose other avenues. And as you can see right here on the screen, Tim Pachedu said, those who are still wondering why Triple C will be on the SADC top agenda in the coming months. This is what they have said, and let us take a look and reflect. I hope that I will be able to continue with this presentation. Can somebody confirm if you are hearing me loud and clear? Okay, so this is the first part of the report here, and they say reasons why Triple C ditched the court route to challenge the electoral theft, and they cited Article 11.7.1 and of the SADC principles and guidelines governing democratic election. So 11.7.1 says, during the post-election period, the SEOM shall observe the conduct of procedures and the processes concerning electoral complaints and challenges by citizens, prospective voters, and those seeking those seeking election, including the provisions of effective remedies for violations of electoral-related rights. This is the article they've cited. And they say inherent to this principle is that domestic remedies available in terms of the law of a member country must be effectual. An aggrieved party who can show that domestic remedies are not effectual is not obliged to exhaust them. This is the position which Triple C has used, and I believe that with this legal position, it gives them an advantage because they actually state that they're not obliged to actually follow the internal remedies as was suggested by some experts. So they're saying domestic remedies present themselves largely in the availability of judicial remedies. It is those that must be evaluated before a party can be required to exhaust them. Okay. In the case of Zimbabwe, those remedies are not available at all. The Zimbabwean judiciary is fully and faithfully captured. Infamously, Emerson Mnangagwa has bragged that he is the army, the police, and the judiciary. a claim typified by the continued incarceration of Citizens Coalition for Change (CCC) senior official Job Sikala on trumped-up political charges, which were meant to exclude him from the elections. Indeed, one of the CCC candidates, Godwin Hakata, won the National Assembly elections whilst in prison, having been arrested for taking part in a car procession on his way to a sanctioned rally. Zimbabwe lacks a functional separation of powers. The executive fully controls the judiciary, and that is enabled by a skewed appointment system in terms of which Mr. Mnangagwa has staffed the courts with his sympathizers. Though Zimbabwe is a public interview system that precedes the appointment of judges, it is an open secret that the results of those interviews have been religiously ignored. Okay, so these are key issues here being raised by Team Triple C, and it's very important for us to actually exhaust. So Triple C went on to, this is still the introduction. They went on to say, this lack of separation of powers has led to the politicization of judicial institutions. Various judgments that have come out of the courts show beyond any doubt that the judiciary is disposed towards Mnangagwa and does not consider itself bound to the constitutional ideal of independence. For this reason, even judges whose behavior has been errant have, upon pledging loyalty to Mnangagwa, been spared from giving account. A case in point is that of Justice Tinamora, whom Judicial Service Commission recommended must face a tribunal arising out of clear misconduct. Though Mnangagwa is constitutionally enjoined to appoint such tribunal, he has not done so to date. Going into the elections, Justice Chinamora had more than 10 electoral challenges found in all against the challengers and is definitely paying back Mnangagwa for his decision to protect him. In that regard, it must also be noted that the Chief Justice designated all High Court judges as the Electoral Court judges, but only a handful, being not more than 5 judges, had the matters in the Electoral Court. The following, however, puts beyond any doubt that the fact that no judicial remedies are available to the CCC in the aftermath of the disputed non-election of the 23rd August 2023. So this is the introduction delivered here by the Triple C, and it's part of the highlight of the reasons why they say that they cannot approach the courts. So they cite the Chief Justice and they say, in terms of the Constitution of Zimbabwe 2013, Chief Justice Luke Maleba ought to have retired on 15 May. And it's true, Chief Justice Luke Maleba had his tenure extended by 5 years because they say that they wanted him to be part of the ongoing process of the 2023 elections. And Mnangagwa unlawfully amended the constitution to extend Malaba's retirement age to 75. The first time a war constitution was amended to accommodate one person and a judge at that. The extension was a fool's errand because in terms of the constitution, any extension of the term limit must not benefit the incumbent. And we all agree that that is the constitutional provision which is available, that the incumbent does not benefit from from whatever amendment which is done. So let us go to the second page here. Okay, the matter was litigated up to 3 judges who held that Malaba's term did on retirement. appealed to the Supreme Court. Notwithstanding they had exercised their right, they were arrested and nullified the judgment of the High Court. As a result of this judgment, Malaba has continued in office. In the run-up to the elections, Malaba issued orders in chambers in the Kasukwere matter without hearing parties. He solely dismissed applications that could only be dealt with by 7 judges. He has shamelessly played the part of which he was hired. In any petition, Malaba will this is deliberate, but ndozvairi it's weak. Okay, zvikanzi panapa. So I'm going to be brief with this report, Team Zimbabwe. We won't be able to continue reading this issue, but let us quickly raise the issues here. They raised the issue of Bharat Patel, and Bharat Patel is one of the judges who benefited from the extension of Luke Malaba's tenure iri kunziyo iri bogus. So he's one of the people who benefited, and there could be one of the presidential who will be sitting during the presidential petitions if one is to be filed. So they raised that point. They raised the issue of the bribed judiciary. Remember, there's an issue of mafia 400,000 akapiwa majaji recently. They raised that issue, and it shows that there are no prospects of justice being delivered through the courts where the judges have been given such huge amounts of money. So they also also cite the issues of Markham versus this matter was brought to court, but captured all and the regime. There is an issue of Monzora versus Zek. In Monzora brought a case that the application was dismissed unlawful, and in dismissing the application, the court did not say the exercise was lawful. They also cites the statutory instruments and amendments to the electoral laws